Today we are dissecting a crushing adjournment decision made on January 15th by a bench with Justices Vikram Nath and Sandeep Mehta. The bench granted an adjournment in a case that's been hanging around since 2008, the MC Singla appeal. I'm Nisha Bhattacharya and my co-host is Priyanka Chakraborty.
And the reason for this adjournment sought by the fourth defendant per Supreme Court Annexure A of the same date is best described as the seemingly flimsy grounds of personal difficulty. Was this another example of an institutional litigant successfully using weak personal excuses to stall judicial proceedings?
Or worse, a case of a failure of the judicial institution to distinguish between a valid legal impediment and a dilatory tactic by a powerful respondent against an appellant, an aging cohort of bank retirees appellant. It is, isn't it, a classic example of process defeating justice and judicial hypocrisy on old matters?
So, our mission today is to figure out why. Why would two really experienced and learned justices who are fully aware of the need for speedy justice, why would they accept such a weak excuse in direct contradiction to Chief Justice Sri Surya Kant's major procedural shift last December to prioritize cases of seniors and other vulnerable groups?
And we're going to approach this from two angles, right? First, we're going to use two powerful lenses. First, a practical kind of functional analysis. You could call it legal realism to get inside the precious judges face.
And second, a really rigorous constitutional law perspective to see, the human cost of a decision like this on the elders of India's banking.
And that's what makes this so tragic, but also so revealing. The core irony here is the appellant, MC Singla, is long deceased. Furthermore, between 2008 and 2005, an estimated at 223,600 bank retirees have joined MC Singla in eternity without getting the justice they deserve.
18 years.
18 long years? That delay is already a denial of justice, and now the process is being halted again.
This is a complex legal scenario that touches upon the very nerve center of the Indian judicial crisis, the tension between procedural due process and the right to speedy justice.
We're watching this tension between procedural fairness, making sure everyone gets heard, and the fundamental right to quick justice just sort of play out in real time.
18 years, you have to just let that sink in. The time span of this litigation is longer than many major world conflicts.
So let's get into the hard facts of what happened on January 15th. This bench was due to hear the matter MC Singla appeal, a case with significant constitutional implications. It's not trivial.
And the specific request for the delay came from who?
It came from Punjab National Bank, which as respondent number 4, citing this phrase's personal difficulty in a note filed with the court.
Okay, and the initial reaction to the adjournment request was pretty sharp. Our sources called it objectively indefensible on merit.
And they also point to the Supreme Court's case management hypocrisy. So what justifies that kind of strong language?
Well, it's not just how weak the excuse is, it's the context. The case was listed as item 117.
Yes. So imagine a court docket for the day. It's a huge list. Item 17 is way down that list.
This means the justices were deep into their workload, probably late in the afternoon.
And now they're staring down this dense, complex constitutional matter, MC Singla, that's going to require intense focus.
Precisely, and in that context, to just accept a vague plea of personal difficulty from a huge institutional litigant like a bank, it signals a willingness to just punt the decision.
So if it's not the merit of the excuse, it has to be about something else, institutional fear maybe.
Right? This brings us to the mindset of the judges themselves.
Why would seasoned jurists like Honorable Justices Nath and Mehta, knowing the stakes for the 7 lakhs bank retirees, allow a powerful bank to use such a flimsy excuse? What was that about?
This sounds like pure judicial risk aversion. If you talk to judges, their single biggest professional nightmare is the remand.
Can you break that down for us? What does a remand mean in this context?
Sure. A remand means a higher court, or the same court in this case in a review, overturns a judgment. It sends the entire case back down the chain for a rehearing.
And that usually happens when a party argues they were denied natural justice, right?
Exactly. The famous legal principle Audi Alteram Partem, the right to be heard.
The right to be heard.
The judges are rightly concerned that if they proceed without a key respondent there, ex parte as it's called, the bank will come back later and claim they weren't properly represented.
So they could argue that crucial instructions couldn't be given to the lawyer who was there. So even though the excuse was weak and the delay possibly immoral, the justices likely reasoned that it is better to delay justice by another month than to deliver a verdict that can be challenged as procedurally flawed.
Because that would create a fatal flaw in the judgment. It opens the door right up for a remand.
So, in the justices' minds, they are choosing the path of, let's say, maximum procedural safety. They'd rather have a guaranteed 4-week delay than risk delivering a bad judgment that's reversed 6 months down the line.
That's a great way to put it. It's like submitting a paper late to avoid handing in a flawed final draft.
Right. They prioritize the technical perfection of the record over the substantive human urgency of the appellant's life.
And this is exactly where the source material criticizes the enforcement of the court's own rules.
Because there are rules against this, aren't there?
Yes, absolutely. The Supreme Court rules from 2013 and clear precedents, like a 2011 case, MS Shiv Kotex versus Tirgan Auto.
The Supreme Court ruling strongly criticized the rampant culture of unnecessary adjournments in courts, emphasizing the need for prompt justice delivery and discouraging misplaced sympathy for dilatory tactics.
So, when the justices grant a vague delay for a case that's been in their own court since 2016, they are effectively ignoring their own guidelines. They're prioritizing the bank's procedural shield over the deceased appellant and bank retirees' right to closure.
That distinction, procedural shield versus human closure, is key. Let's zoom out from the judges and look at the systemic pressures. This is where this letter for circulation culture comes into play.
This is a huge thing. It's a pervasive, almost informal convention of the Supreme Court. The advocate on record, the lawyer who files the papers, can circulate a letter just before a hearing asking the bench to adjourn.
And the reasons are often pretty routine, like the main lawyer is unavailable or
a key client is ill. And while the court has tried to clamp down on this, the benches still accept these letters all the time, especially in older, more complicated cases.
because the whole system is just crushed by docket pressure.
It is. Now let's look at the PNB Excuse again through that lens. It's an institutional litigant. It's not, one person who woke up with a fever.
Right, an institution can't suffer from personal difficulty.
Exactly. A corporation, a public sector bank, it has a huge hierarchy. If the general manager can't be there, another officer should have been deputed instantly to give instructions. The argument is, frankly, intellectually bankrupt when it comes from an institution.
So if the excuse is flimsy and the rules say no, this is where that legal realist view really tells the true story.
And I'm speculating here. The bench is looking at item 117. It's a dense constitutional case. They probably knew a full continuous hearing was impossible that day anyway.
They didn't want to start a complex constitutional argument at 4 o'clock in the afternoon and only get 30 minutes into it.
By granting the adjournment, they guaranteed the case could be properly heard on a clean slate in the near future.
So it's institutional convenience disguised as procedural courtesy. Bottom line, we are prioritizing the court's calendar over bank's retirees' constitutional right.
And that convenience often shows you who has the power. What's so fascinating here is the total lack of any financial penalty. They just gave the adjournment. They didn't impose heavy costs on PNB for wasting the court's time.
Why is that absence of cost so significant?
Because it reflects a deeply conservative approach. It's treating the state, or in this case, a huge PSU bank, with what the source calls undeserved leniency.
And the critic suggests this goes back a long way.
It does. It suggests this is a relic of the colonial mindset where the crown, or today the state, is automatically given deference in the courtroom. It's almost never penalized for wasting judicial time.
So the powerful litigant gets two things: the courtesy of the delay and immunity from any financial accountability for causing it.
It allows them to use stalling as a tactic with zero consequence. It is the definition of justice deliberately delayed.
And that leads us right to the heart of the human tragedy here. The 7 lakhs bank retirees in their 70s and 80s who are in an unwinnable race against time. At the rate the Supreme Court is moving, many retires will pass before the process is done.
It's devastating to say that, but true.
Of course. And the moment the process requires the petitioner to die before the process is completed, the system has failed fundamentally.
And this is where the constitutional law perspective, the NSLIU analysis comes down so hard.
Absolutely, because it reminds us of the core jurisprudence under Article 21 of the Constitution. That article guarantees the right to life.
And the Supreme Court itself has said repeatedly that this includes the right to a speedy trial.
It does. So when litigation drags on for 18 years, the process itself becomes the punishment.
The state has already violated a fundamental right, whatever the final judgment says.
It's not just a delay, it is literally the process defeating justice.
Our sources are unsparing on this. It labels this incident as an example of institutional cowardice masquerading as courtesy, and this connects directly to a wider issue of elite case management.
Tell us more about that concept. What does that mean in practice?
Well, Dr. Mohan Gopal, who's a former director of the National Judicial Academy, he observed a very distinct pattern. When a poor litigant or maybe a young inexperienced lawyer asks for an adjournment for perfectly good reasons,
The Supreme Court benches can be incredibly ruthless. They'll often refuse the delay or impose heavy costs.
but when the powerful show up,
When the request comes from the Union of India or a huge PSU bank like PNB or a very influential senior advocate, the court becomes, in his words, infinitely accommodating.
and the frivolous adjournment of the MC Singla case on January 15th is a perfect example of that.
It's the textbook example, the power dynamic, the identity of the litigant.
It ends up trumping the strict rule of law and the constitutional mandate for speed.
What a profound and disturbing summary of a systemic failure. This one adjournment just reveals the full constitutional irony. The MC Singla family, fighting for their rights since 2008, is having their case slowly killed by the very system designed to protect them.
All because an officer of a public sector bank had a personal difficulty that wasn't worth the court's trouble to deal with. The justices weighed the risks, the risk of a procedural flaw versus the risk of ongoing human suffering.
And the judges chose to the side of a flawed procedure over bank retirees' right to life and dignity in old age.
Thereby making the prospects of bank retirees waiting for 18 years much worse.
So, what does this all mean for you, the listener, especially if you are dealing with a drawn out legal process yourself? Is there any way to actually challenge this rule of convenience that seems to favor the powerful?
Our sources offer a very pointed and I think actionable strategic suggestion that could shift this dynamic immediately. The petitioners, legal representatives, bank retirees, unions should not just file an application for an early hearing.
Okay, what should they add?
They should include a specific prayer in their application. They should ask the court to impose exemplary costs of, say, 5 crore rupees.
Okay,
Personally, on the specific absent officer of PNB who claimed to have a personal difficulty.
on the officer, not on the bank? That changes everything.
It changes everything
Yeah.
because it forces accountability away from the faceless institution and onto the individual human being concerned.
And what does that do to the bench?
It puts them in a corner.
Really? How so?
They'd be faced with a clear choice: either hear the case immediately and deny the frivolous delay, or they would have to explicitly ignore this request for personal accountability against an elite institutional player.
And in doing so, they would publicly expose the exact double standard of elite case management that Dr. Gopal talked about.
Precisely. It's a fascinating strategic move that kind of weaponizes the court's own reluctance to enforce true accountability.
So, until petitioners start taking these assertive, targeted steps, that forces the courts to choose between their procedural safety and real personal accountabilities.
The finding remains clear. In 2026, India's apex court sometimes functions not strictly by its own procedures but by the rule of convenience. And that convenience almost always aligns with the powerful.